of argument prepared with regard to this matter. Right, in the nature of things, I've also prepared some notes concerning the ruling I must make. As crystallized by the state, sorry. The state intends applying, and it indeed applied, to call the evidence of Sergeant Mokgano pertaining to what is related or narrated by the state as the automatic vehicle location system. The state has argued that this evidence relating to the requirement by itself to re-examine Sergeant Mokgano concerning this automatic vehicle location system is not new evidence. The state argues that this evidence arises from the cross-examination and the assertions put and made against Sergeant Mokgano by Mr. Mngomezulu, when he put it to Sergeant Mokgano that his client was taken to various locations after having been taken from the Pretoria police station with the intention of being taken to the Boksburg court, but allegedly Sergeant Mokgano, who was the driver of a vehicle identified and put to him by Mr. Mngomezulu as a Fortuner, white in color, with a hard body. And this is the vehicle which Sergeant Mokgano concedes, accused number 4, was transported in. Consequently, this evidence, this piece of evidence, regarding the fact that this vehicle, the Fortuner, SUV, is not new in the sense that it is interlinked to the evidence of the automatic vehicle location system, because that system forms part of the vehicle allegedly driven by Sergeant Mokgano. And this is the assertion which is put by Mr. Mngomezulu, for instance, that this vehicle was driven to various locations. And during the stops at these various locations, it is also put to the sergeant that he was assaulted by, amongst others, Mabena, Jonathan, etc. And consequently, that's why this court is saying, strictly speaking, this is not new evidence, in the sense that when you talk about the automatic, the AVL system, it is part of the vehicle which was used by Sergeant Mokgano and his colleagues to transport the accused to various locations with the intention of assaulting him in order to coerce him into making a confession. The other aspect which this court has to deal with is the fact that when the re-examination of the sergeant was being done by advocate for the state, he had only just finished testifying in chief and having been taken under cross-examination by Mr. Mngomezulu. In the same court, this is not a case where you find a witness testifies and is cross-examined, and allegedly the cross-examination and the re-examination is finalized, and the witness moves out of court, goes to the Kruger National Park for a holiday or to be employed there. And after 3 months, 6 months, the state gets a brainwave to recall that witness. No, this witness is contemporaneously and instantaneously testifying in this court. When Mr. Baloyi launches an application to re-examine this witness on the system, which allegedly tracks, he says it's an eye in the sky, it tracks the movement of the vehicle. This court must start maybe with the fact that once the prosecution has decided, after gathering evidence, to prosecute a person, the Constitution of this country kicks in. So too does the National Prosecuting Authority Act kicks in. And at that time, the state then is seized with presenting evidence to this court in order to prove its case against an accused person beyond a reasonable doubt. And also Section 35(5) of the Constitution kicks in, because after the accused has been charged and prosecuted, he is entitled to be given an opportunity, a full-blown opportunity, to rebut the state's case and to challenge any evidence which is adduced by the state. And don't get me wrong, there is no onus on the accused to prove his innocence. The onus reposes always on the state. So the duty of a prosecutor is to place material evidence, material relevant evidence before this court in attempting to prove its case against a particular accused. And correspondingly also, although it is not an onus on the accused has the right to place evidence before this court challenging and rebutting the evidence which was led by the state. And the accused also is entitled to adduce evidence to contradict and countervail the evidence which is led by the state. And these are interactive constitutional duties. The court, after having listened and heard the evidence adduced by both parties, this evidence obviously assists the court in ascertaining what the truth or where the truth lies. Consequently, this court must hear all the evidence, if it is available, and if it is material, and if it is relevant. In Cooper, Du Toit, De Jager, Pijzers, Skien, and Van der Merwe, the commentary on the Criminal Procedure Act, in relation to section 150. This is what the learned authors say regarding the reopening of a state case. And in this case, the state case is not closed, and I dare say the state case in some instances can be closed. And the state, if there is a cogent reason and exceptional circumstances, can launch an application to reopen its case and recall evidence or further adduce evidence of a witness who never even testified in that case. If it is in the interest of justice, the SCA has held that that exigency should be allowed. But like I say here, we are not even dealing with that exigency. For instance, in the case of Joseph Molula, it's case number 074/2014. It was heard on the 18th of August. The judges were Brandt, Busielo, Zondi, Fori, and Matopo. In this case, it was already on appeal at the SCA. You can read it. It was already on appeal at the SCA when the state made an application to adduce new evidence right in the SCA after the case was argued. Now that tells you how potent the interests of justice govern our law relating to fairness and fair play. And the only debate the court had in this regard was whether the further evidence should be adduced in terms of affidavit, or the court must be remitted back to the High Court for that evidence to be heard. But the principle is, as late as that stage where, a person was sentenced to 15 years imprisonment, and it transpired in this rape case, allegedly, the lady was infected with herpes, but the attorney who was defending the gentleman who allegedly raped her and infected her with herpes, no medical examination was conducted because of that exigence. And this case was handled by my brother Mushidi. The SCA said that exigency is so important because it's determinative of whether that person will be acquitted or not. And in fact, after this gentleman was examined, it was found that he does not have herpes. So he couldn't have had intercourse with this lady. But I'm just trying to demonstrate how far the scale goes. Sorry. So the paramount reason after the state has decided to prosecute a person is that the state must conduct such prosecution without fear, favor, or prejudice That is the duty which is imposed on Mr. Baloyi. And that the state should not take improper shortcuts in the presentation of the case for the state, and that proper evidence must be made available. Proper real evidence should also be produced, because the prosecutor is enjoined to act with objectivity, and he's enjoined to protect the public interest, and must purposefully take all the reasonable steps to ensure maximum compliance with the constitutional obligations, because a prosecutor has an obligation to ensure that an accused's right to a fair trial is protected. And this is so because of our constitutional adversarial criminal law justice system. Consequently, the prosecutor must carry out his professional functions with a discretion, and his decisions must be taken judiciously, impartially, and objectively. Consequently, I now address the question whether this evidence relating to a report of the AVL system should have been furnished to the counsels, consequently the accused, at the inception of the trial. But Mr. Baloyi says this evidence only surfaced when Mr. Sergeant Mokgano was being cross-examined, because it was only then that the version of accused number two was being put to Sergeant Mokgano, namely that he was taken to various avenues and locations and assaulted, meaning that this Peugeot, this Fortuner SUV, traversed various locations, and consequently the state apparently is in a position to countervail that evidence, because at this stage there are two versions before this court. Sergeant Mokgano is not himself only. Jonathan, all the police denied that accused number two was assaulted by them, and number two is adamant that he was assaulted. They actually told him, is he still alive? That's how murderous they had assaulted him, this police. And you know, this case has got to do with reputational damage. Two senior police officers, Mbodlo, who allegedly took one of the confessions, and Rapadu, who allegedly took the other confessions, they are alleged by accused number two to have been instrumental in orchestrating what Mr. Mgumezulu calls a severe assault and a severe torture of accused number four in order to extract a confession from him. These are senior police officers. This court has a duty, if constitutional rights of an accused person are being transgressed, to refer that exigency to the relevant authorities. Consequently, that is why this court must have access to all the evidence in order to traverse all the evidence objectively. I've got a case here which was conducted by Ronald Sutherland, the Deputy Judge President of the Transvaal. Where he states that if it comes to the notice of an investigating officer during his or her investigations relating to forensic or scientific analysis of real evidence, that police officer must immediately inform the prosecutor about that exigency. And he says this is so because the investigating officer is in a special representative position vis-a-vis the prosecution, because he assists, as an investigating officer, the prosecutor to prepare the case and to prepare the evidence. And in this case, for instance, the learned judge says, because of that exigency, and because the versions which are disclosed by accused persons for the first time happened during cross-examination, and if the state wishes to pursue that aspect of evidence, because the state requires amplification or clarity, or clarification, or qualification, or simply an explanation, those matters need to be followed up, and if needs be, postponements should be sought to investigate the correctness or otherwise of the facts underlying the testimony in question. And it may well be that such a practice is not attainable in every case because of logistical restraints. But because persons could be convicted because of the charges they face, and they could be sent to drastic terms of sanctions following the conviction, it follows that the investigating officer ought to be mandated in terms of standard prosecutorial and police procedures to investigate further. See in this regard the case of S versus Sibofi, 2015, 2 SACR 179 GJ at 169. As I say, the judge was Sutherland. It was an appeal case. He was sitting with Justice Opperman. So in other words, there is no definite time when you say the state can no longer investigate. I just showed you proof that even when the matter is before the SCA is being argued, if there is a necessity to investigate a certain exigency which may have a bearing on the outcome of the appeal court says, in the interest of justice, that case must be remitted back. That additional evidence must be traversed. So in this case, it is unfair. Actually, the law doesn't even countenance it. It is unfair to accuse Mr. Baloyi of having dragged his feet and not having, as Mr. Mgomezulu states, made it a point that he investigates before charging the accused. No. As late as when Magano was being exposed to those assertions that they took the accused to various locations and assaulted him, if the state comes across evidence, and I'm not arguing the state's case, which evidence may throw light as to whether that exigency exists or not, the court is bound and obligated and enjoined to hear that evidence. But here I hear Mr. Mgomezulu say, no, don't investigate. Don't listen to that evidence. I'm listening to the same case. He says, no, you mustn't listen to that evidence. Really? Is that evidence relevant? Is that evidence pertinent? Is that evidence going to enable the court to reach to the truth of what happened in the exigency which is denied by this witness, Mr. Sergeant Mokhano, and which is insisted upon by accused number 4. Consequently, the adversarial and accusatorial nature of criminal trials in South Africa demand that parties should, as far as possible, be given equal opportunities in the presentation of their cases. As I said, the state must be accorded all the opportunity to call and adduce relevant material to prove the owners reposing on it beyond reasonable doubt, and the accused should also be accorded a full opportunity to present evidence in rebuttal of the case against him and to challenge any evidence which is so presented. See in this regard the case of S versus Mpeta, 1983, 1 SA 492C at 494A to C. And see also the case of Director of Public Prosecutions, North Gauteng, Pretoria versus Makubelo, case number A91/2014, decided on the 6th of August 2014. And these prosecutors are not practitioners who represent clients, but prosecutors are public officers who should assist the court in ascertaining the truth. And to enable the court to see that justice is done, the prosecutor is expected at all times to act in a manner which is responsible and fair to the accused, and to be open and candid to the court. Consequently, he's going to present and place all the material before this court, as Mr. Baloyi is attempting to do. He says there's evidence which, according to him, if this court can hear, it may find that it is relevant. I don't know if that evidence is relevant or not. And the prosecutor's duty, unlike that of a defense counsel, his primary duty is to assist the court in ascertaining the truth. See in this regard S versus Razini versus Director of Public Prosecutions, Western Cape, 2009, 1 SACR 540C at 549H to 550A. And see also the case which has been quoted by Mr. Kumalo and Mr. Baloyi, as versus Ramalope, 1995-1, SACR 297, Orange Free State. And also see versus Sabisa, 1993-2, SACR 52-5, Transkei. And see also as versus Goma and others too, 1994-2, SACR 182C. But critically, this is what the TOIT says. And I appreciate the various counsel quoting me section 166 regarding cross-examination and re-examination. But this is what the TOIT says. There is no absolute rule that the trial court's discretion to admit evidence for the state after the close of the defense case should be limited to the situation when new matters is introduced which the state could not foresee. That's the law in South Africa. I'll repeat it. There is no absolute rule that the trial court's discretion to admit evidence for the state after the state has closed, after the close of the defense case should be limited to a situation where new matter is introduced which the state could not foresee. An inflexible rule of this sort would hamper the exercise of the judicial officer's discretion. They say I mustn't listen to the evidence. It's an injunction. Each case depends on the facts and the guidelines mentioned in the judicial case, and the new evidence may be allowed without injustice to the accused. Even here, where's the injustice if this court listens to the evidence of the AWVL system? Where's the prejudice to Mr. Tansi? Where is it? I don't know what the evidence is going to be. But the state submits that if need be, the manufacturers of that system will be called to come and give evidence in explaining the mechanism of that system. And by the way, the accused, through their counsels, are entitled to cross-examine that witness who's going to testify on the efficacy and the utilization of that AVLW machine. So there's no prejudice in hearing that evidence. I take note of what Mr. Mngomezulu says about the evidence of an expert. I'm aware of the cases. And also, I take a judicial notice of what the former president of the SCA, Mpati, said about expert knowledge. He says it's not only acquired from going to university and reading tomes and tomes of books. Sometimes through physical and objective environment of working in a particular workplace for some time, one acquires expert evidence sometimes. You can quote the case of Dr. Barnett, 1968, when he transplanted a heart as the first surgeon in South Africa to do so. He was assisted by a black gentleman, I just forget the name of that gentleman, who actually taught him how to operate. Never went to school, that Xhosa gentleman. And he was acknowledged as an expert in anatomy of the heart. You are aware of that history, Mr. Mngomezulu?
No, I'm not aware.
You're not? Were you born then? 1968, says Barnett. So Mpati is referring to that. To say, no, you don't have to study necessarily to acquire expert knowledge. You can acquire same by being in the environment. Okay, so in the case of S versus Fulton, 1999, 1 SACR, 481 SCA, it is also quoted by my learned colleague here, Ngumala. Conditions mentioned by courts as guidelines include the following: the reasons why the evidence was not led previously. Because in this case, apparently, Mr. Baloyi says it was only discovered when the version of accused number 2 was put to Sergeant Mokhano. The degree of the relevance of the evidence. This evidence is relevant to this court because it involves, allegedly, through the version of accused number 4, senior officers, colonels, abusing their position and infracting on the constitutional rights of accused number 2 by assaulting him viciously. So that is the relevance of that evidence. Because I will have forensic, scientific evidence of a machine, not a human being. And I'm sure a machine is not biased. I've heard everything, but I've never heard of a biased machine. So, it is relevant. And the reasons why the evidence was not led previously, as explained by Mr. Baloyi, is that it was just found recently, and also the possible prejudice to the other party, such as the fact that a rebutting witness may no longer be available. Mr. Ntasi, accused number 2, is available to rebut that evidence. The stage at which the proceedings have reached, we are in a trial within a trial. And the general need for finality. See also the case of Hadla versus President Insurance Company Limited, 1965, 1 SA 614A. I think I have it here. I'll post it for you. Yeah. Yeah, this is a civil case, which is relevant if you want the citation so that you can check it out. It's Hadla versus President Insurance Company Limited, 1965. 1 All South Africa Law Report 603A. It was hit on the 24th of November, 1964, before appeal judges Van Blerk, Ogilvie, Thompson, Rumpf, Holmes, and Williamson. It also dealt with the exigency when can one reopen a case, and what are the consequences if you do so. Sorry, let's check. Yes, consequently then, using my judicial discretion as enunciated in section 197 on the notes under the commentary on Criminal Procedure Act, this is what it is said. A judge has a discretion to exclude cross-examination even if it should be technically permissible in terms of section 197, if it would unduly prejudice the accused. But in this case, the accused is not being prejudiced. But here they say, if the cross-examination or the re-examination of that witness, which is intended to be called by Mr. Baloyi, is going to be prejudicial to the case, to the fair case standard which our Constitution insists on, then this court should exclude it. And they say the exercise of this discretion may be appropriate where the prosecution, as opposed to a co-accused, seeks to cross-examine the accused in terms of subsection B. And then they refer us to the case of State versus Mazibuko and others, 3 SA 198 at 197, where it was said that no discretion is conferred by the language of section 197B, and that there is a considerable body of authority which supports the view that the court which relates to the prohibition or to restrict such cross-examination on grounds of irrelevancy at all. But here, this evidence is relevant. Like I say, it's interlinked to the evidence which was given by Mokgano, and it is also interlinked to the assertion which were put to this witness that that vehicle traversed certain locations, and that vehicle facilitated the assault on accused number 4, because it took him to Tembisa, Orlando, Alberton, Baragwanath, everywhere. So that the cogency of that evidence, I believe, can assist this court in establishing the truth. And they say if the evidence is relevant, then it operates as a legal rule. Although of necessity, it has to be very flexible, and it's not to be subjected to further vagaries of a judicial discretion. I've quoted all the authorities. I don't have to read them. But the primary principle here is it in the interest of justice to allow that evidence to be heard? Is that evidence which Mr. Ngomezulu says I shouldn't hear, is it relevant in this case? On both accounts, I find that it is, and consequently the state is allowed to lead that evidence. Okay.
Udaba belumayelana ke nobufakazi umbuso ofisa ukuthi ubethule ubufakazi bokuthi le moto ekuthiwa ke uSergeant Mokgane naye avumayo ukuthi yayishayelwa uyena ngaleli langa ekuyiFortuna emhlophe, ukuthi ke kulethe ubufakazi obutshengisayo nanjengoba kuneyinsolo ezibuya kuyena umsolo wesibili ukuthi le moto lena yahamba indawo eziningi kunala eyemakhona, yahamba yaya ngase Orlando ila ashaywa khona, kwahanjwa kwayiwa futhi naseBaragwana la ekwathola khona uSergeant Raphat. Inkantolo ke ithi ke manje uma kubhekwa ke okuningi ke noma ke ibheka amacala amaningi ke ayiholayo noma ayitshelayo ukuthi kungani ke ukuthi ngabuvumela noma ingavumela yini lobo bufakazi. Okokuqala kusho ukuthi akusibona ubufakazi obusha lobo, ukuthi lo bufakazi bothulwe noma buze ungathi kumeli kaMsola wokuqala nowesibili. Yena ke uadvocate Ngomezulu uma ebuza lo bufakazi uyena ke owethule noma owelethe lobo bufakazi, nokuthi kungani umbuso eqaleni ungabuvezanga lo bufakazi. Umbuso uphe iphenduleleke ngokuthi bona ke bebengazi ukuthi umsolo wesibili uzoyiphendulela athini ke kungenkathi ufakazi lona ke esethula ubufakazi bakhe la khona ke bezozwa khona ukuthi uphendulela athini, nokuthi futhi ke lo bufakazi babuthole nge-3 zika November, kwakungolesihlanu nge-3 zika November ngathi ke buthunyelwa uyena umphenyi oyinhloko kulelicala uBrigadier uGininda. Ilapho ke asengidlulisela lokhona lobo bufakazi budlulisela kubona ke abameli lo bufakazi ekhulunywa ngabo ke ubufakazi beAVL athi umshushisi futhi uma iphendulela ukuthi ubufakazi obungasiza lenkantolo kule insolo eyilethwa uyena umsolo wesibili ukuthi washaywa le moto yaphuma emzileni la ekwakufanele ukuthi ihambe khona yase iya kwezinye indawo la ashaywe khona ke. Uthi lo bufakazi ubufakazi obungasiza lenkantolo ukuthi ngempela ibone ukuthi cha la ekwakumele ihambe khona le moto lena yaqezwa ke yaphumela eceleni ila ke manje esekungashiwo khona ukuthi insolo zakhe umsolo wesibili ngempela ke ziyaphatheka ke nokuthi ziyiqiniso ke. Ekugcineni ke inkantolo ithi uma isiwafundileke wonke amacala lana ke ayiholayo noma ayitshelayo ukuthi kungani lobufakazi bungamukelwa noma bungamukelwa ukuthi ngempela ukuthi abusibone ubufakazi obusha lobu nokuthi ukhona umnumzana uNtanzi ula enkantolo uzoba nalo ithuba lokuthi aphikisane nakona lokho egcineni ke inkantolo ubufakazi obungasiza lenkantolo ukuthi ifinyelele kwiqiniso futhi nokuthi ke futhi ke imfuno noma ke idingo zobulungiswa ke ziyakuvumela ke ukuthi lobufakazi lokho inkantolo ingabulalela ngoba izofinyelela kanjani kwisinqumo ekuyisona ingekuzwanga ubufakazi okumayela nokuthi le moto lena yahamba kuphi nendawo ngaleli yalanga ngokusho kanjalo ke umehlulela uthatha isinqumo nomfikele kwisinqumo sokuthi lobufakazi lokho bekuthiwa beAVL abethulweke la kuzokuthi wonke umuntu abone ezwe khona ukuthi le moto yahamba kuphi ngalelo langa lelo.
Biale Sajeni botlhatsi bola ba lena jwalo ka ga ile gore motšhotšhisi le ba boleledi ba latofatswa bona be bantse ba bolela ka bona gore bona ba dumela gore mo botlhatsi bo ba lena bo amogelwe go ba botlhatsi ba lena bo ska amogelwa ntate Baloi yena Mamotlhafurugo o yeme a fitla a khopela a phaphata go khoro gore botlhatsi ba lena bo amogelwe bo tle bo khone go theletswa ka lebaka la gore botlatla bo thusha mo molatong woke ye leng gore ntate Mngomezulu irile ga emelela yena a re a wa botlhatsi bo ga botlo thusha ka selo gape go tlo nyaka le gore go bitswe le ditlhatsi tše dingtšela tše leng gore di bese di fane ka botlhatsi ba tsona go tshwana le bo Mabena le bo Jonathan le bo Buthelezi le ba bangwe gore le bona batle ba boye ba tlo fana ka botlhatsi gore ke nnete ba sepetse le lena le sepetse tsona dilo tše fapafapaneng tše leng gore go bolelwa ka tsona mo molatong woke ge le gore lena botlhatsi ba lena botlo swanela gore bo theletswe gape bona bo Mngomezulu ba re ke botlhatsi bo eleng gore ke bo boswa bo eleng gore ga botlo thusha khoro ka selo ka lebaka la gore lena botlhatsi bo ga se le bolele ka bona ge be le fana ka botlhatsi ba lena mathomong e fela ntate Baloi irile le yana ga yemelela a se a khopela khoro o ile re ga se botlhatsi bo boswa ka lebaka la gore botlile ka moraga gore bona bo molatofatswa ba bobedi e be bona ba eleng gore ba le butša dipotšišo tšeo we di feletše ile gore di dira gore lena le arabele ka tsona ditaba tša gore koloi ya lena ile ya tswa tseleng goba ga se nke e tswe tseleng jwalo ka ga bentše lena le ilo dira mošomo wa lena kana letšatši leuwe ke mo eleng gore khoro jwatse irile ge re boya ka moraga gore khoro e setse e be irile re tšea nakonyana khoro e re ge ke tsopola khoro yona e re botlhatsi bo ba lena ke botlhatsi bo e leng gore bo botlhokwa gape ga se botlhatsi bo boswa jwalo ka ga e le gore ke dilo tše e leng gore mo khorong yona e ga se gore lena le ile la sepela la ilo shoma kholo tulotshoko mo eleng gore mohlomong lena le ile la ilo shoma ntoweng parking yela Kruger National Park mo eleng gore irile gele boya ye be le gore le nyaka go botšišwa dipotšišo tšewe gape khoro e re go molato wo mongwe eleng gore o fetile go na le mo be setse molato wo o leng Supreme Court of Appeal mo be motšhotšhisi a ileng a kgopela gore ke kgopela go bitša tlhatsi goba ke kgopela go bontšha botlhatsi bo bong bo boswa ke mo eleng gore khoro yela ya Supreme Court of Appeal ile ya re e re theletše gore botlhatsi bo boswa bo reng ke mo eleng gore go molato ola motho ola o feleditše a bonwa a se molato ka moraga gore go theletšwe botlhatsi bola bo boswa gane jwale botlhatsi bo khoro e re ga se bo boswa jwatše bona ke botlhatsi bo e leng gore bo ka thusha go molato woke ntho ya mafelelo e khoro e bolelang e re botlhatsi bo yona ya dumela gore lena le ka tswela pele motšhotšhisa le botše dipotšišo ka bona lena le tswele pele le arabe gore molato wo o tle o kgone gore botlhatsi bo fele ya be le gore molato wo o tswelela pele. As the court pleases, thank you my lord.
Thank you. Yes Mr. Baloi.
Please, my lord. By the way, the gentleman who assisted Professor Barnard was one Mr. Hamilton Naki.
Yeah, Naki, yeah.
Yes, he was a lab assistant. He didn't have formal education, but he had amazing surgical skills, and he was teaching medical students, physicians. Yes.
Yeah. We knew that, Mr. Ngoma. Umnyama sport. Yeah, he was an amazing gentleman, amazing. You know, the structure of a heart. You know, I took human beings over 2,500 years since the Romans first had an operation and the Greeks, for a guy to take out somebody's heart and replace it. And here's a guy from Etigeni can do that.
Okay. The state will be leading evidence on the movement report, which has been marked Exhibit MM2.
MM2.
Yes, and it will only be, my lord, for the 9th, as mentioned, will be confined to the 19th of June 2020. I'm told by Advocate Ngumezulu that he wants to place something on
record. Okay, yes, Mr. Ngumezulu.
God bless my lord. My lord, I've indicated to my colleague that I would actually note that I'll bring an application for a special entry.
Yeah, fine.
To be made, not at this time, my lord, as I've indicated. I requested that this application should be brought after the evidence of the investigating officer, Brigadier Kininda.
Okay, fine.
The court pleases.
Fine.
And my lord, further, I don't the state has what type of evidence they need to lead in respect of this document, but we have finished with 2 copies. And the incident relating to the assault, as the court has mentioned in the judgment, relates in other days that the state is not intending to produce in one of these bundles that we were given. So I was given 2 bundles marked MM2, but the other one is reduced from the date of the 19th, and the version that I put to this witness starts from the 16th. And
so you want the bundle to start from? They must start from the 16th.
From the 16th, my lord.
Yes. Okay. Mr. Baloyi.
Court, please.
As a court, please, we can make that, but as the state indicated that we.
What's that?
We can do that, but we are of the view that the issues that are in dispute at this stage relate to the 19th of June 2020, and the.
Wait. Yeah, I hear you.
Yes.
Where do you have the record of the 16th?
Yes, it starts
where?
on the 4th of June. It's a whole book, my lord. That
starts on the
1st of June.
1st of June.
Yes.
So, Mr. Ngumezulu, you say you want it as from the 16th.
From the 16th.
You don't want the whole book. Maybe he should give you the whole book.
Not, because I believe this is the bundle that consists of the dates bearing the 16th of June. It's marked MM2.
Yeah, MM2.
Yes, my lord. We'll focus mainly on the
16th.
From the 16th onward, because our version starts from the 16th.
So, Mr. Baloyi, why don't you provide your colleague with the bundle as from the 16th, as he says?
Yes.
Hello?
Yes, we can do that, my lord. As I say, the bundle that we have starts. In fact, I think we've already provided them with that document.
Which document is it?
The one that starts from
the 16th.
That covers the dates on that my learned friend is referring to.
What is the problem? Don't you have the document that starts from the 16th?
Yes.
You have it?
Yes, we do have it, my lord.
Yeah, give it to him.
We will do that, my lord. But as I said,
but he wants it before we start. Is that so, sir?
I recently got this document for the 16th.
Yeah. So
yes. But now, according to the submission by the state, they intend to lead evidence from the 19th. And according to the version
you put
to the witness,
starts on the 16th.
It starts from the 16th. What is of crucial importance, the 17 hours that we alleged was the time in which he was subjected to torture.
Yes.
It's on the 18th preceding to the 19th. So we say the state cannot start.
Yeah, I hear you,
Yes.
As a court, please, for the sake of completion, so we have a document that starts from the 1st of June. If it's in order with my learned friends, we can hand up these documents. It starts from the 1st of June and goes all the way up to the 24th of June.
Is that okay?
Yeah, looks like they're happy with that, my lord.
Yeah, hand it over so that...
We'll then ask permission to hand up, it still remains exhibit MM2.
Starting from the 1st of June.
Yes.
Yeah.
Yes.
Okay.
And this document, my lord, that we've just handed up as exhibit MM2 consists of 43 pages. We've numbered them. Pages 1 up to page 43.
Okay.
Page 1 covers the 1st of June 2020. And page 11 covers the 5th of June 2020. Then page 14 covers the 16th of June 2020.
14.
No, 16 June,
Yeah.
page 14, yes.
40.
1-4.
1-4. Okay.
Then page 24 covers the 18th of June 2020.
18th of June.
Yes. 18th, 1-8.
On 8.
Then page 32 covers the 19th of June 2020. This is the page that the state will be canvassing, 19 June 2020. Then the last page 43 covers part of the 24th of June.
Page 43.
Yes, page 43, 24 June.
4 June.
But that will not be helpful as this vehicle was not used on that particular day. A different vehicle was used, not the Fortuner.
Yeah.
Maybe on that note, my lord, it's time for the long adjournment.
Oh, that's
Can we then take the long adjournment?
Okay, fine. Okay, let's adjourn.